All right, it is the top of the hour, and out of respect for everyone who has shown up on time, why don't we go ahead and get started? My name is Neil Morgan from Morgan HR. We are a partner with Trusaic and excited to work with them today on this webinar. Morgan HR is a 16-year-old compensation consulting company based in Chicago, and we work with all sizes and industries on building meaningful and effective aligned compensation programs. We like to say that we're in the business of making compensation feel fair, relevant, and right. I head up the technology side of our business with a product called Simply Merit. And Simply Merit is a modern compensation management solution focused squarely on helping companies manage merit, bonus, and equity grant cycles. Companies like Abbott Labs, Alzheimer's Association, Welch's, all trust Morgan HR for their compensation needs. We recently announced an integration with Trusaic from our Simply Merit platform to allow our Simply Merit customers to automatically transmit their compensation data to Trusaic to do the pay equity analyses that Trusaic is so very well versed on doing. And today I have the honor of introducing two very special people from Trusaic as they walk through pay data reporting as it relates to the annual compensation cycle. So first up is Joanna Kim Brunetti. She is a Vice President of Regulatory Affairs at Trusaic and has a very tenured career advising clients on a wide range of employment, tax, IP, and other related business issues. She holds a degree in chemical engineering from UC Berkeley and a JD from Loyola Law School. Next slide, please. Also today we'll be hearing from Mark Dwyer, former senior economic consultant for the Harris Economic Group, where he's provided written and oral testimony regarding the implementation of empirical analyses. He directed data cleaning and construction of empirical models in a variety of industries and has worked as the senior economist for Econ One Research. Additionally, he's taught econ as an assistant professor at UCLA, at Rice University, and Australian National University. Mark has a PhD in economics from the University of Rochester, an MA in finance from Wharton, and a BA in physics from the University of Pennsylvania. So with that, why don't I turn it over to Joanna so she can start us out and introduce the content for today's slide and get going on the topic.
Thank you so much, Neil. Welcome, everybody. I'm sure that, with the pandemic raging to new heights, there's been a lot on our minds. If we could go to the next slide. Well, okay, sorry about that. So, there's with the pandemic kind of on everybody's mind and really raging to new heights, the downstream economic damage is going to be equally dramatic. And unlike the financial crash of 2008, the housing mortgage crash, this COVID-19 economic downturn has and will continue to more job losses for women and minorities, underscoring their pay inequities. So, here are just some of the independent research that we identified, all of which make the same point, that this current economic downturn is going to have a disproportionate impact on women and minorities. Next slide. So, it should come as no surprise that the disparate treatment is going to be part of that explosion of COVID-related claims that is predicted to happen in the near future. Next slide. Okay, so with that, we also want to note, next slide, that independent of the pandemic, there's been significant activity that continues in parallel of the need to pay attention to pay inequity that's going on. So as you can see here, sorry, we could go back one slide. Okay, so what you see is I've laid out there a number of countries internationally, although it's mostly gender focused, some also consider race and ethnicity. But what you'll see is starting with the UK in 2017 and then kind of more of a flurry of activity 2019, 2020, is this increasing urgency with respect to achieving pay equity and the various ways that pay equity can be achieved. So you've got UK starting in 2017, and then you have Iceland in 2018, and then followed by Spain in 2019, and then in 2020 we have Switzerland, Germany, Canada, and France. So you can see the sort of acceleration of activity in the pay equity space. Other notable non-EU regions include Victoria, Australia, which has put something into place that's effective 2021, and then Canada, which is anticipated to be effective sometime this year. Okay, next slide. So drilling down more. Next slide, please. Okay, so with the UK, what we have are variations in employer size requirements and exactly what that requirement is for pay equity. I'm sorry, we're having a little bit of technical issues on the slide control. Can we go back one slide? Because I think you jumped a couple. Okay, so in the UK, employers with 250 or more employees have to publish on their website what their gender pay gaps are. So this sort of method of achieving pay equity is is kind of the shaming process, where you're posting what your pay gaps are. And currently, it applies in the gender space, but there has been talk about considering expanding this requirement into the race and ethnicity gender pay disparities space as well. In France, it's instead of a sort of a pay gap, it's a different type of metric, but basically trying to accomplish the same thing. Employers have to publish their gender equal pay index score. And so it's a slightly different calculation, but again, it's the same objective of identifying what the pay gap is, and it applies to a much smaller size employee, employers with at least 50 employees. And even further, even smaller is Iceland, where their pay equity approach applies to 25 or more employees. And instead of a pay, sort of a shaming type of publishing on their website like the UK, what they actually require is independent certification that pay equity was actually achieved. And this certification is required every 3 years. And in Germany, which is the latest, there's a number of proposals going on. So beyond Germany's existing Equal Pay Act, which is active transparency of pay, they have been talking this year about sweeping gender equality proposals, which would basically target all departments in the German government, and as well for identifying and requiring at least 30% of senior management personnel in German stock market listed companies to be female. These are still kind of in flux right now, but there is significant activity going on in Germany. Next slide. Okay, so in Spain, they have, basically employers with 50 or more employees, they have to develop and release gender equality plans. Switzerland, employers with 100 or more employees have to conduct an internal gender pay gap. Canada, they have a 3-tiered system, but that go down as low as employers with only 10 employees that are required to implement a pay equity plan. There's, basically this tiered system also requires, in addition to the sort of pay equity plan, they also need to Sorry, I got a technical glitch here. They have to form a pay equity committee responsible for implementing the pay equity plan. All right, next slide. Okay, so that is the international backdrop. And again, there's been sort of increasing urgency for mechanisms to achieve pay equity. Now back to the US, the federal structure for pay discrimination really starts with the Equal Pay Act back in 1963, and the sum and substance of it is the 1963 one, which is gender only. Employers have to pay equal wages to men and women performing jobs that require substantially equal skill, effort, and responsibility, and are performed in the same establishment under similar working conditions. And there were 4 justifications for gender pay disparities, which is an employer could justify a pay differential between men and women based on seniority, merit, a system which measures earnings by quality, quantity, or production. This is basically, for example, if you get paid by the number of widgets that are being processed. And then a 4th factor, which is a differential based on any factor other than sex. And it is this 4th factor which creates the largest gap in enforcement. So almost in parallel, a year later, we have the 1964 Title VII of the Civil Rights Act, which then expands the notion of discrimination not just to gender, but also to race and ethnicity. And this also applies in the pay discrimination space. And like the Equal Pay Act, it also allows for the 4 justifications I mentioned. Okay, next slide. So there's been, a couple of additions since then in the federal law for pay discrimination. 1978, the Civil Service Reform Act, and in 1991, the Civil Rights Act of 1991, which increased compensatory and punitive damages for intentional discrimination. So basically, adding further nuance to the Civil Rights Act for the benefit of employees. Okay, so that's the federal legislation. Next slide. Okay, so in addition to that, we also have the administrative law space under the Equal Employment and Opportunity Commission, the EEOC. And basically, since the 60s, the EEOC had instituted this EEO1 reporting, which is basically collecting workforce, gender, and race ethnicity data from employers. And it was in the space of a number of specified job categories and over a number of pay bands and a number of job categories, and employers with 100 or more employees, in essence, had to report the racial and gender makeup of their workforce. That was the component 1 of the EEO1 reporting. More recently, under the Obama administration, they had created this component 2 reporting, which basically adds on to the component 1 the pay data element over a number of different pay bands. And there was some, a flux in the EEO1 component 2 reporting because under the Trump administration, they halted it. There was some litigation, so it went back in effect for just the 2017 and 2018 year. And now with the incoming Biden administration, component 2 may be reinstated. Now, the chart that I showed to the right of it is an example of what you might see coming out of the EEO1 reporting. And what you see is, there's different job classifications from executives down to associates. And, you see that this is not specifically identifying pay per se, but what it shows is, the percentage of men and women, in these different job classifications, and that might be something that comes out of the EEO1 reporting. And notably, even though we're not talking about pay, what you see is at the top at the executive level, you see much more men, the higher percentage of men on the executive level, and at the bottom in the associates, you see a higher percentage of women. And that's where sort of the diversity, equity, inclusion aspect doesn't necessarily get captured in a pay equity audit. So that's something else to keep in mind. So, we've had this EEOC, EEO1 reporting in place for, since the 60s. We've had federal law, prohibiting pay discrimination, yet there still is this huge pay gap between men and women and between whites and minorities. So there's clearly something that isn't getting fixed in terms of pay equity. And it is this absence of comprehensive federal legislation to address pay equity that's left this void. Next slide. Okay, so what has happened? The states have come in and filled in, and really in a flurry of activity over the last few years. And the ways to achieve pay equity, they have been, there's different approaches. They're not mutually exclusive. Those approaches include expanding the definition of substantially similar and comparable work. And there's a number of states that have done that recently. And what that expansion of the definition is, rather than kind of, limit an employee who's claiming pay discrimination, instead of limiting that claim to, well, you got to only compare yourself to a person with a, for example, like the same job title. What this does is it broadens that, so you have a larger pool of other workers to compare to, and it makes it easier, frankly, for an employee to claim pay discrimination. Additionally, another significant trend is limiting the affirmative defense against pay discrimination. As you may recall, one of the factors of the 4 factors that employer can use to justify pay discrimination, one of them was that 4th factor, which is basically a differential other than sex, which sounds extremely broad. What many states have done is said, well, that 4th factor has to be limited to, must be job related and consistent with business necessity or a similar type of limitation. So it's got to be job related. You can't be just any old factor. Another trend is salary history bands. There's 19 statewide and 21 local salary history bands, and that's really been just over the last couple of years. And what these salary history bands are basically prohibiting employers from asking a job applicant what that person was getting paid in their last job. And the theory is that if there is, kind of baked in discrimination, pay discrimination, if you use a person's prior salary as a basis to negotiate that person's salary, what you're doing is you're just, perpetuating that salary discrepancy. So if Susie got paid $10,000 a year and John got paid $15,000 a year in their past job, and the employer is negotiating and can use their prior salary history, it is very common that Susie would ultimately get paid in the new job less than John, even though they're otherwise equally have the same qualifications, etc., because her prior salary history was considered in establishing her pay in the new job. Another area is equal pay safe harbors, and there's 3 states in particular: Massachusetts, Oregon, and Colorado. Again, as you can see, it's really been fairly recent. Massachusetts and Oregon have essentially what is a safe harbor for, in Massachusetts case, it's a complete defense against a state law claim of pay discrimination. And in Oregon, it's more limited. It's for punitive damages and liquidated damages. And what the safe harbor is, if you conduct a pay equity audit and you make reasonable progress towards achieving pay equity, you can use the fact that you did an audit as a defense. And in the Massachusetts case, it is a complete defense. So that's extremely, extremely valuable. I'm sorry, Oregon, it's the defense is against emotional distress and punitive damages. In Colorado, which is often called Safe Harbor Light, the defense is just for liquidated damages. So these are ways to, employers, ways that employers can protect against, state, pay discrimination laws. Okay, so next slide, additional trends in pay equity, different approaches are increasing emphasis on pay transparency. So in New Jersey, there is an approach to require certain public contractors to submit an equal pay report to the government. And in the Colorado equal pay for equal work, which is going to go into effect next year, there are proposed rules to expand job posting. It's basically that how broadly this applies, it's still not so clear. But basically, the compensation, including salary, bonuses, and commissions, those have to be posted. So that's, this concept of pay transparency. And a different, slightly different approach in California, they're requiring diversity on boards. So a law that went into effect this year has expanded from past in 2018, where basically publicly traded companies had to have at least one female on the board of directors. And now with SB979, the board also has to have one person from an underrepresented community. So these are all sort of different approaches to, sort of filling the void of federal law designed to, against pay discrimination and achieving pay equity. So now California is the first to require pay data reporting among the states. And that's really, we're going to get into the nuts and bolts of that. And, California is often a leader in sort of employee rights. And so, there's a real question as to, are other states going to follow? So you can see on the chart to the right, there, if you compare the dark blue versus the light blue, there's basically more sort of protections for employees in the pay discrimination space in the light blue versus the dark blue. Okay, so you can see that it's, sort of, generalizing, it's often sort of coastal communities that will, be sort of the first to lead in this space. Okay, next slide. Okay, so we just talked about pay reporting, or just hinted at it, and this pay reporting is under SB 973, which goes into effect in less than 30 days. So what is it? Well, the people that are affected, or the employers that are affected, are private employers with 100 or more employees who are required to file an annual EEO1 report and have at least one employee. So, kind of going into, well, how do we figure out if I'm an employer, if I fall into that category? So let's say you have 100 employees in Nevada and you have one employee in California, you are covered. So what does that mean? What do you got to do? Well, the reporting is very much modeled after the EEO1 component 2 reporting that I mentioned. SB 973 requires gender and race, ethnicity, pay data across 10 job categories, very much like the EEO1 component 2 reporting. And importantly, the gender in California is a little different than under federal law. It also requires you to identify non-binary. So, assuming that applies to you, you would have to identify over the job categories in the different pay bands, the race and gender, whether it's female, male, or non-binary, and ethnicity for all workers. Okay. So what about remote workers? In that 100 count, teleworkers are going to be included. Remote workers, especially in this COVID space, working outside of California, but then report to California establishments, they have to be included. Okay. Another thing that's important that is really has been adopted based on the EEO1 component 2 and component 1 reporting is that when you're figuring out the 100 employees, you as an employer, if you are part of a single enterprise, i.e. If you are with other companies that are affiliated based on centralized ownership, control, or management, you're all those entities are going to be combined to figure out whether or not that 100 employee threshold has been met. Okay, next slide. Okay, so I just went into that. Okay, so basically, the reporting is going to be due. The first deadline is March 31st, 2021. And so, in a nutshell, employers with 100 or more employees, will have to submit this report. It is for a snapshot period, which we'll get into in a little bit, in 2020. And it's going to be reported. The first one is, a little bit more than 3 months away, and it is for a period that is already, that has already happened. Okay, so the bottom line is employers are going to now have this brand new significant compliance obligation to track and report pay, workforce demographics, and hours worked data. While the full extent of the enforcement of SB973 is not fully fleshed out yet, but the law expressly aims to receive, investigate, conciliate, mediate, and prosecute complaints alleging and to bring civil actions pursuant to the California Equal Pay Act, which is, against pay discrimination. Okay, next slide. So, I had alluded to basically that SB 973 is in part designed to, help enforce the, California Equal Pay Act. The SB 973 pay data reporting is going to be enforced by the Department of Fair Employment and Housing, DFEH, and the DFEH has express authority to compel an employer to comply. And failure to do so includes, basically paying for the cost for the DFEH to order your compliance if that's where they have to go. It's important to note that the DFEH can obtain from the EDD the names and addresses of all businesses with 100 or more establishments. So they're going to know who has complied and who hasn't. And the DFEH has express authority to, among other things, issue subpoenas, send out interrogatories, conduct depositions, and seek documents, and to seek court orders. And the DFEH, along with the Division of Labor Standards Enforcement, are expressly authorized to basically coordinate and adopt procedures to enforce the California Pay Act. Next slide. Okay. So one thing I wanted to mention is confidentiality, because the annual pay reports, which are coming due annually, these are reports that are confidential from the standpoint of individually identifiable information, i.e. person's name, date of birth, things like that. Information that would identify a person, that information is considered confidential and not subject to disclosure. However, the DFEH will maintain these annual data reports, pay data reports, for at least 10 years, and they are entitled to publish on an annual basis and publicize aggregated reports of basically whether it's just to kind of show benchmarks by industry, for example. But the DFEH is authorized to basically publish these aggregated reports, provided that it doesn't actually identify any individual person. And the Division of Labor Standards and Enforcement can use the information from the annual pay data report as needed upon instituting an investigation or an enforcement under the California Equal Pay Act. Now, so if you submit the report, which is going to be required if you're beyond a certain employee size threshold, the content of the data is ostensibly confidential, but it's important to note that a plaintiff, if you get sued, such as a former employee alleging pay discrimination, can always, as part of the litigation, get a copy of the annual pay report from the employer and or potentially subpoena the report from the DFEH. So confidentiality is, confidentiality asterisk. Okay, so getting more into the nuts and bolts of the SB973, let me transition over to Mark.
Thank you, Joanna. That's a great introduction. So next slide, thank you. There are three areas I'm going to try to touch on over the next few slides. One is, how is the pay and hours data most likely to be reported? What kind of format and what kind of structure that reporting will have under SB 973? How that reported data is likely to be used? How employers can protect themselves from the potential misinterpretation of their submitted data as well. So to start off, I wanted everybody to have access to the authoritative source on how the pay data will be submitted, and that's the Department of Fair Employment and Housing. They have a website devoted to the topic, which they last updated November 23rd. It has a lot of information on it right now. I'm going to try to summarize some of it, but it's also got a lot of stuff that's not been published yet. So that's the site to watch if you're subject to this reporting requirement. So as Joanna mentioned and discussed, the SB973 is modeled on EEO1 Component 2 data reporting. And so that's probably the best guide, short of the website being fully specified as to what the submission will actually consist of. So there are a few caveats to that, and as Joanna mentioned, one is that if you filed Component 2 for 2017 and 2018, you know what that looks like, you know what the structure that is. You also know that you don't have to do it this year, as Joanna just described. So, but if you have that mechanism in place, that's a very good starting point. So, like Component 2 from that was filed with the EEOC for a couple of years. The DFEH says they'll accept this in a comma-separated format, and that, for instance, image files or PDFs are not acceptable, but a CSV file, which is the same file format that was used for Component 2. I'd also point out that on the top right here, the portal management, so who's actually doing the collection work? It looks like that's going to be NORC, the same company that the EEOC contracted with to do the Component 2 reporting. And that's significant because on the one hand, we've got that the SB 973 is modeled on Component 2. We've got the same contractor collecting that data, and also NORC also had a big hand in the construction of this file format that was submitted under Component 2. So they're probably going to want to use something very similar here. There are some differences, though, and Joanna's hit some of those. The first is the non-binary gender under California law. So even though DFEH says that they will accept Component 2 submissions, they have to contain the same or substantially same pay data information. And where you might run into a problem, an employer might run into a problem there, is that if they have employees who are identified as non-binary in terms of their gender, then the federal form would not be applicable. Okay, second, Component 2 allowed for a summary single row submission for smaller establishments. It was called a Type 6 report. It was just a head count at smaller establishments. Whereas DFEH has not said anything about allowing that kind of summary information. They are talking about per establishment filings. But a third part of a difference, though, is that with the federal filing, you were filing for all of your establishments, whereas under SB 973, you're only filing for establishments that employ California employees, whether that establishment is located in California or it's outside California, and those California employees are working remotely. So that said, though, DFEH has indicated that they will accept full outside California establishment submissions. So you don't have to for the purpose of SB973, cut your establishment data for submission. If the establishment is outside of California, you can submit that. There's no bar to that. But if you wanted to cut it so that it only reflected your California remote workers for, say, someplace you had in Reno, Nevada, or something like that, you're able to do that, and that's a difference from the component 2 filing. Okay, can we go to the next slide, please? Great. So this I'm putting up here, this is sort of the structured descriptive form. This is not what you'd actually submit or was actually submitted under component 2, but it's the conceptual form that was used for component 2. So what I want to highlight here, just a few facets that NORC took and then made into a much more condensed format. So the first is that if you look across the columns, you see that we've got the gender and race ethnicity laid out there. And so we've got 7 different race ethnicities and 2 genders in the federal form. And those are coded A through N, excuse me. Okay. So in the California, that may be expanded to 21 categories to allow for non-binary gender interacted with different races and ethnicities. But the basic idea of a coding of CODING, a coding that represents a gender and race ethnicity combination, is most likely to be used in the submission forms as well. On the left-hand side, we see 2 columns. One is the job category column, and the other one is the salary band column. And in the first column, the job category, only 1 of 10 is shown here, which is the executive and senior level officials and managers. That's also got a number associated with it, a 1. So one way in which you can compress, and in which NORC compressed and made more efficient the data submission, was you would just use the number code for your job category. Then in the salary compensation band, you also see here for each job category, there are these 12 fixed salary bands, and those are also indicated by number 1 through 12. So these codes are going to did play a big role in how component 2 was structured when it was actually implemented, and are most likely to be driving how the submissions will be for under SB973. Just to finish this off, this is one of 2 forms, conceptually speaking. This form would be filled out with a number of employees that are in a given job category, a given salary band, and have a given gender and race ethnicity makeup. Okay, so that's what this form would be. There's an identical form where you would put in the total hours that those employees worked. Okay, the same structure, but it would be the hours form instead of the employee count form. Okay, so now let's move to the next slide. There we go. This is what these component 2 submissions really look like. And so you can see here, so first off, there's one form. It's not a form for each establishment and one for the whole organization. Everything is in one file. And it's going to make heavy use of those codes that I just described, and it did, the component 2, and most likely SB973 will as well. So you can see on the left-hand side, we've got the employer, the company, identified by a user ID. Then the next several fields are just describing a given establishment. So there's the address and so on, the state zip code and so on for a given establishment. And then on the right-hand side, we see the job category code. Those run from 1 to 10. The race ethnicity codes, A through N. The annual salary band, the salary compensation band, 1 through 12. And then there are just 2 columns. One that has the employee count, and one has the total number of hours worked. So this admittedly large file potentially would cover all establishments, would cover all pay bands, all race ethnicities, all gender, both genders or all genders, and have all that data in one file. And that's what's actually what was submitted under component 2, and is most likely the kind of CSV format that will be available to you and largely required under SB973. Okay, next slide, please. There we go. So one of the that sort of covers an introduction to what is being submitted and how the submission's most likely to be structured. What I want to turn to next is how that data will be used, and just give some of the analytics behind how the pay data will be processed. And this is based on pilot studies that the EEOC conducted back in 2015, and those same there were techniques discussed in that pilot study, and there's no reason to think that California would not adopt many, and maybe add to them, but at least adopt many of those same methods. So what I've done here is taken data for a particular job category. This is for sales. And so that's actually job category 5 in the coding. And then one of the things that you need to submit, in addition to per establishment submissions, is a consolidated or summary submission, which takes all establishments and adds that data up across all establishments. So this is looking at consolidated data for job category 5, that is ICE sales workers. And then across the top, just like we saw in the earlier form, we have the different genders and race ethnicity codes. And here A through K are represented. And then down the left-hand side, just as we saw before, we have the different salary bands that apply to any of these groups. Okay, so it's not all of them, but whichever ones do apply are listed here. And then we have employee counts. So the focus right here is on how would the annual pay data itself be used, okay? So one very straightforward way of analyzing this is to just look at who on balance has a higher weighted average annual compensation in terms of their gender and race ethnicity versus another group. So that's what this middle row here of weighted average comp is describing. So we see here for gender and race ethnicity C, which happens to be white male. This data is illustrative. It's an example. It's not from a real company. So they're in the highest of these salary bands. There are four employees, white male employees, in the highest of these salary bands. Category A represents male Hispanics. They're also heavily represented in salary band 7, but there are also some in salary band 1, okay? All right, so when you look at the weighted average compensation here, what you see is that there's variation, right? Some are high and some are low. And so that's a first issue that regulators would look at, is to see what do these weighted average compensation levels, annual compensation levels look like? Do they vary? Do they vary in a systematic way? Are there patterns across establishments? Are there patterns across job categories? So those are the kinds of things that they would be looking at, which would create flags for them. That's a first kind of analysis, is just looking at weighted average annual compensation comparisons. The second one is a little bit more involved, and that's a statistical test. You can also do a statistical test on those weighted average compensation measures, but I wanted to jump to another kind of test, which is a distribution test. So what this does is it looks at two columns, like A and B, which are male and female Hispanics, and it looks to see whether there's a significant, from a statistical point of view, difference in the allocation of people across those different salary bands. Okay, so when that number is very small, that bottom row, and I've highlighted the very small numbers in red, which are very near zero, there's a strong indication that the distribution of employees across these salary bands differs. Okay, so relative to column A, columns D and I and J all vary rather substantially from that column in terms of the distribution of employees across different annual compensation levels. So this is another flag that regulators will look at to see within a job category where those distributions are out of alignment, and where they're most egregiously out of alignment, and where there may be systematic patterns of misalignment. There could be lots of valid reasons for why these are happening. And on the left-hand side, I've described some of them. So I worked in this example. I wanted to illustrate some of those. A very simple driver at this in terms of annual pay as to why there can be differences. So I constructed this data so that A through D, these different genders and race ethnicities, all actually have the same wage rate, the same hourly wage rate. But what they differ in is in terms of hours. Okay, and since people who work different hours in the year are going to have different annual compensation, even if they're all paid the same hourly rate, you get these distributions, the different alignment of employees across those categories, those salary bands for A through D. I, J, and K are not paid the same wage rate, and that's reflective of the fact that there are legitimate reasons why people are paid differently. Okay, it could be experience, it could be skill level, it could be technical training, responsibility, or working conditions. And so there are a lot of legitimate business factors, which we'll come back to quite often, that there's just really very limited ability to communicate to the DFEH why salaries for some groups are different from others, some workers are different from others because of these underlying legitimate factors, different responsibilities, different working conditions, and so on. So in any event, they're running these. They're likely to run these statistical tests as a filter to flag establishments, to flag employers, and so it's good to know that these are being applied to your data, and that there could be legitimate reasons for why these flags are being set off, because the regulator doesn't have information about what the legitimate drivers of these wage differences are. Okay, next slide, please. So in that last slide, one of the key driver there for the groups A through D was essentially the only difference between them was when they were hired in the year, and yet they create flags for the regulator because their weighted average annual compensations are different, or the distribution comparisons are different. So what I wanted to point out is that the data is you're also submitting, an employer's also submitting their labor, their hours data. So you can combine the hours data and that salary band data, and you would think that that would largely resolve this issue about discrepancies, apparent discrepancies in pay among equally paid employees. But it doesn't, and that has to do with the sort of lumpiness, the approximate nature of these pay bands. So you don't know where workers lie within these pay bands. These pay bands are usually around 20 to 25% variation in terms of their width of the different annual compensations they include. So you have a lot of variation in there, and so even though again A through D here are all being paid the same hourly wage, because they're binned with these broad salary bands, when you divide by their total hours, you don't get the same answer back for an hourly wage. You get substantial variation of up to 26% in the first case between male and female Hispanics. That's columns A and B here. Even though there's really no wage difference. So this is just on an hours issue in terms of what's being submitted. It doesn't even begin to touch the other factors, the business factors that I described, which are working conditions, responsibility, skill, effort, those types of factors, which are critically important to determining wages and are not communicated with these data. All right, next slide, please. Right, so just sort of summing up what that where we are on that. What I've been trying to hit on here is that SB973, like Component 2 at the federal level, is only showing a very approximate picture of pay differences, and it's really reflective of raw pay gaps. The 4 legitimate business factors defining substantially similar are skill, effort, responsibility, and working conditions. Those are not communicated through your SB973 filings. It does control broadly for one of these 10 job categories, and there is an establishment control, so there's something about location. And we saw that we can also control to some extent for hours worked, but there's a lot that's left not communicated to the regulator, and a lot of reasons for a regulator to get a false positive that there's an issue with your pay data when there may not be. the real way to remedy this is to be proactive. Okay, employers will want to run the numbers in conducting a pay equity audit to understand what their pay practices are and where there may be issues with their pay that are unexplained by their business factors once you actually incorporate them. So that's sort of the bottom line here, is that with this submission of the data and with all the confidentiality issues that Joanna raised, it's worthwhile and prudent to consider conducting a pay equity audit. So let's next turn to the next slide, and we'll touch on what a pay equity audit is. Okay, so we've broken this up into just a few bullet points here. So what does a pay equity audit do? Okay. It's an analysis of your workforce that identifies pay disparities that are not explained, not just the raw pay gaps that the SB973 makes apparent, and it identifies these underlying any pay disparities that remain by placing statistical weights for legitimate business factors that you're able to document that defensively reduce the raw pay gaps. Okay, that would otherwise seem apparent there. So. In doing so, this quantifies risk for an employer. If the data you have collected and retained on legitimate business factors does not completely explain pay differences between protected classes such as different genders and race ethnicity combinations, it is important to know how large that disparity is, and a pay equity audit provides you that quantification. In addition, a pay equity audit helps to identify root causes. So. Let me also point out here, in terms of also, in addition to quantifying risk, pay equity audit also helps to specify a remediation strategy. That takes at least two forms. One is in terms of specifying actual compensation adjustments, but the other is determining, because you have this risk quantification, you have a sense as to how much it might be worthwhile to invest in getting those in finding or uncovering those legitimate business factors that might be missing from your analysis so far, your accounting of pay. It also may help with root cause identification, such as are there commonalities of location, position, or hiring cohort that align with the observed pay disparities, or are pay disparities more evident among recent hires or among ongoing continuing employees? Another element of a pay equity audit is that it provides information on another part of the submission to the component 2, which is the counts, right? So what is your distribution of employees by job category, by different genders and race ethnicities? The pay equity audit also helps you to assess that and whether it's reasonable, whether it's out of alignment with publicly available data or not. So that can help with recruitment, retention, and with relations with customers and investors. And then finally, it's important to note that employers can involve their internal or external legal counsel to establish privileged communication protocols for the pay equity audit. Conducting a pay equity audit is a separate decision from the degree of transparency that an employer provides regarding the results of the pay equity audit. And that's really what this issue of privilege is meant to communicate. These are separate choices that a employer makes, provided that they maintain and institute the proper legal safeguards. Okay, next slide. Right. So I just want to give a little bit of the also just to touch on the context of pay equity audits. Pay equity audits use statistical analyses, and it draws on the same tools and the same approaches to statistical wage modeling that are used in litigation context. They're used both in terms of proving cases, of passing summary judgment in cases, and also in terms of settlements and programmatic relief efforts. Both these same types of statistical tools that are used in pay equity audits are also used there as well. So you're getting some foresight into potential legal risk in a litigation context as well. Okay, next slide, please. So just a couple of motivational quotes here. There are risks and costs to action, but they are far less than the long-range risks of comfortable inaction. And a pay equity audit is really an action that is a worthwhile investment. In any moment of decision, the best thing you can do is the right thing. The next best thing is the wrong thing, and the worst thing you can do is nothing. So, with this reporting requirement on the horizon for SB973, don't do nothing is the recommendation. Next slide, please. Okay, so there are two broad ways of conducting a pay equity audit: do it for me or do it yourself. Trusaic convened a panel of HR experts to get their feedback on these different approaches and on different aspects of pay equity in general. Do it for me is a little bit of a misnomer, and it's actually more accurately to think of it as an external partnership, a partnership with an external. And such an example would be the partnership between Morgan HR and Trusaic. In terms of the complementarity in your organization, you get to focus on what you're good at and your HR team is good at, whereas we can focus on data cleaning and consolidation, statistical analysis and interpretation, and regulatory interpretation and expertise. And that's where you're going to have the strongest and best outcomes. Organized compensation data feeds, such as Simply Merit provides, can be incorporated easily to conduct a pay equity audit, and is a great way to have that clean, well-defined data enter into the analysis, and the higher the quality of the data going into the pay equity audit, the better the outcomes. So there are two options then for getting started. One is just to get an assessment of your pay gaps, and Trusaic offers a no-cost pay gap risk assessment to identify your potential pay gaps, which is what the SB 973 would be seeing. Okay, so this is sort of giving you at least at no cost to an employer. It gives you a heads up as to what they're likely to see, because we're already in the snapshot period, right? So your data is we're already in the period where you'd be collecting data to submit to California. An alternative is a no-cost pay equity consultation, which Trusaic could offer you to answer any questions you have about a pay equity audit or about SB 973 to the extent that we can expand on comments here today. So with that, I'd just like to launch our first poll question, or our only poll question, which is asking, would you like to receive a free pay gap risk assessment from Trusaic? So again, we'll leave this open while we take any questions that may have been answered or asked by the participants, and give you an opportunity to think about whether you would like to take us up on this offer or not. Joanna, do you have any questions?
I do. So we have one question. It says here, are there other ways that data can be analyzed regarding pay equity than the ones that you've presented?
Oh, that's a good question. Very, very much so. Yes. So it's important to realize that SB 973 has three components to it. It has your employee count data, it has hours data, and then it has annual compensation. And I really focused on using that data for compensation analysis and showed you some of the statistical tools that could be used to make comparisons there. But the count data in itself has to do with diversity, right? So California regulators will also be looking for representation issues, for whether certain genders or race ethnicity seem to be excluded from certain job categories or underrepresented. That's another thing they'll be using that data for. They'll be looking at the hours data to see if hours are systematically low for certain genders or race ethnicities, to see potentially if there are overtime opportunities that are not symmetrically distributed across people, or whether full and part-time status are not are systematically off between employees in different protected classes. So yeah, I haven't covered all the pay analyses tools that might be used. And another big part of that is that your data is going to be compared to other employers. It's not going to be just looked at internally. It's going to be looked across your establishments, looking for the establishment that is the worst case scenario, and then it's going to be comparing an employer to other employers in that same geography, that same industry, again, for those who stick out. And those are the ones that are going to be the low-hanging fruit, so to speak, from the regulator's perspective.
Okay, another question is, can you explain the justification for pay gaps in the SB973 report? I can take a whack at that.
Oh, sure.
Yeah, with the SB973 annual report, you're basically providing the Department of the DFEH the raw pay gaps. So there's no sort of quantifiable means that you can insert into the report. There is a comment section, but it's just a comment section. It's sort of a qualitative explanation. And the bottom line is, if you do the report, you get all the data together and submit the report, which you're going to be required to do. It doesn't really provide a true picture of what pay disparity, if any, there is. It's just going to show the raw data. So you're giving the regulators the information for them to, make, assume that there are pay gaps. And, if you submit the pay report without doing a pay equity audit, you don't know what you've submitted. You just know that you submitted the data. So, doing the report obviously is mandatory. And a pay equity audit may not seem to be mandatory, but you are exposing yourself to risk if you don't do the audit in connection with submitting the report internally. So you know what's out there.
I might add, just
ahead,
if we have time, I might just add to that. I think it's the question might also be asking about what's the regulator's justification for looking at pay gaps, and from that perspective, there was a balance, and this goes back to the EEOC, between reporting burden, how costly their mandated reporting is on employers, versus the information that would be collected. So if a government agency were to mandate that you provide all of your legitimate factors, that might be burdensome for some employers who just don't want to do that. So I think there's a balancing act there. And I would point out that this is a step away from just the overall pay gap that you might be mandated to report in the UK, right? Because you're not averaging wages for service workers and executives. Okay, they are broken out by job category, but that said, there's an awful lot of variation in each of those categories that's not explained.
Right. Okay, I think we're out of time. It's 11:01 Pacific. So with that, we'll end our webinar. Thank you so much for attending. And there in the slides, our information is listed. So if you want to reach out to us, we certainly respond.
Thank you.